Testing, testing, testing. Okay. Department of Department of Transportation, Florida Railroad Code Regular, Title 49, Code Federal Regulation, Part 242, Docket Number 5 RA 2009-0035, Notice Number 22130-ACO8, Conductor Certification, Agency, Federal Railroad Administration, Department of Transportation, Action, Final Rule. Summary: the FRA is in prescribing regulations for certification of conductors as required by the Rail Safety Improvement Act of 2008. The rule requires railroads to have a formal program to certify conductors. As part of the program, railroads are required to formal processing and training prospective conductors, determining that all persons are incompetent before and permitting them to serve as conductor. The FRA is issuing a regulation to ensure that only those persons who meet the minimum federal safety standards serve as conductors to reduce the rate of number of accidents incidents to improve railroad safety. Although the rule does not propose specific amendments to regulation governing locomotive engineering certification, it is highlighted in the regulation that it may require conforming changes. Date effective: the rule is effective January 1st, 2012. For further information, call Mark H. McKeon, Special Assistant for the Association Administrator for the Railroad Safety and Chief Safety Officer. U.S. Department of Transportation, Federal Railroad Administration, RRS 1, Mail Stop 25-1200 New Jersey Avenue, Washington, D.C. 20590. Telephone 202-493-6350. Joseph D. Riley, Railroad Safety Specialist, Operational Crew Certification, U.S. Department of Transportation, Federal Railroad Administration, Mail Stop 25, Room 44, W 38-323, 1200 New Jersey Avenue, Washington, D.C., Southeast Washington, D.C. 20590, or telephone 202-493-6318. John Segan, Trial Attorney, U.S. Department of Transportation, Federal Railroad Administration, Office of Chief Counsel, RCC 10, Mail Stop 10, Westing Building, 3rd floor, Room West 312-217, 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. Telephone number 202-493-6045. Supplementary information: statutory background. Pursuant to Statute 402 of the Railroad Safety Improvement Act of 2008, Public Law 110-432, and 122 Statutory 4884, October 16, 2008, the Code Title 49 U.S. Standard Code 20163, hereinafter of the Railroad Safety Improvement Act, Congress required Secretary of Transportation to prescribe regulations to establish a program requiring certification of training conductors. The Secretary delegated authority to Federal Railroad Administration. Title 49 CFR Statute 149. Section 20163A of Title U.S. 40 and U.S. Standard Code Section 402 of the Railroad Safety Improvement Act provides that the Secretary of Transportation shall prescribe regulations to establish a program requiring certification for training conductors. And prescribing regulation, the Secretary shall require the trained conductors be trained in accordance with the training standards developing pursuant to Section 20162. Section 20163 provides 120-163B provides that developing regulations requiring subsection A, the Secretary must consider the requirements of Section 20135B through E through the requirements of Title 49 U.S. Standard Code 20135 concerning certification of locomotive engineers. Section 20162A2 of the Title 49 U.S. Standard Code Section 401 of the Railroad Safety Improvement Act provides that A, in general, the Secretary of Transportation shall no later than 1 year after the date of an enactment of the Railway Safety Improvement Act of 2008 establish a requirement railroad carrier, contractor, subcontractor developing, submitting training qualifications planning to Secretary of Approval, including training programs, information deemed necessary by the Secretary to ensure all safety-related railroad employees receive appropriate training in a timely manner. Section 20162B of Title 49 U.S. Standard Code provides that the Secretary shall review and approve the plan required under subsection A2, utilizing an approval process required in the program to certify and qualification of the locomotive engineers pursuant to Part 240 of the Title 49 U.S. Standard U.S. Code Federal Regulation. 2. The Railroad Safety Improvement Committee. The Railroad Safety Advisory Committee. In March 1996, the FRA established a Railroad Safety Advisory Committee in which provides a formal collaborative rulemaking program development. The Railroad Safety Advisory Committee includes representatives from all agencies making stakeholder groups, including railroad, labor organizations, supplier, manufacturers, and other interested parties. A list of the Railroad Safety Advisory Committee members are files is the American Association of Private Railroad Car Owners, AARPCO, or American Association of State Highway Transportation Officials, the American Chemistry Council, the Army Petroleum Institute, the Army Public Transportation Association, the American Shortline Regional Railroad Association, American Train Dispatcher Association, and the American Association of American Railroads, the Association of Railroad Museums, Association of State Railway Safety Managers, Brotherhood of Locomotive Engineering and Trainmen, Brotherhood of Maintenance of Way Employees Division, Brotherhood of Railroad Signalmen, Chlorine Institute, Federal Transit Administrative Fertilizer Institute, High Speed Ground Transportation Association, Institute of Mark of Explosives, International Association of Machinists, Aerospace Workers, International Brotherhood of Electrical Workers, Labor Council, Latin American Advisement, League of Railway Industry Women, National Association of Railroad Passengers, the National Association of Railway Businesswomen, National Conference of Firemen and Oilers, National Railroad Construction Maintenance and Association, National Railroad Passenger Corporation, National Transport Safety Board, Railway Supply Institution, Safe Travel America, Secretariat of Decominosa de Transporte, Spanish, Sheet Metal Works International Association, Taurus Railway Association Incorporated, Transportation Canada, Transport Worker Unions of the Worker Unions of America, Transportation Communication International Union, the BRC, and Transportation Secretary Administrative United Transportation Union. Star indicates that non-voting membership. When appropriate by the FRA, assigns a Railroad Safety Advisory Committee. When the Federal Railroad Administration assigns a Railroad Safety Committee, after consideration and debate, the Railroad Safety Committee may accept or reject the task if in the Railroad Safety Advisory Committee establishes a working group of the appropriate expertise, representation, interest to develop the recommendations for the FRA for the action on the task. The recommendations are developed by the consensus of the work group, may establish one or more task force, other subgroups, develop facts, opinions, particular aspects of a given task. The task of the force or other subgroups report to the working group. If the working group comes to the consensus recommendation for action, the package of the Railroad Safety Advisory Committee for the vote. If proposals is accepted, simple majority of the Railroad Safety Advisory Committee, the proposal formally recommended to the Federal Railroad Administration that determines what an action to take of the recommendation because of the FRA, the Federal Railroad Administration staff play an active role in the work group leveling, discussing the issues opening to the draft language of the consensus proposal, being that the Railroad Safety Advisory Committee recommendation constitutes a consensus for the sum of the industry leading experts for the given subject. The Federal Railroad Administration, often favorable inclined to the Railroad Safety Administration Railroad Safety Advisory Committee recommendations. However, the FRA is not bound to follow the recommendation of the agency. Expertise exercises or independent judgment through whether the recommended rules achieves agency regulatory goals. It is sound supported that in accordance with the applicable policy legal requirements, often the FRA varies in some respects of the Railroad Safety Advisory Committee recommendation developing actual regulatory proposal or final rule. Any such variations would be noted and explained in the rulemaking document issued in the FRA. If the working group of the Railroad Safety Advisory Committee is unable to reach a consensus of recommendation for action, the FRA resolves the issue through the traditional rulemaking procedures, other actions. 3. The Railroad Safety Advisory Committee Conductor Certification Work Group. On December 10, 2008, the Railroad Safety Advisory Committee accepted the task number 08-07 entitled Conductor Certification. This purpose of the task was defined as follows: to develop regulation certification of railroad conductors as required by the Railway Safety Improvement Act, to consider appropriate related amendments. 2. The existing regulations. The task of the Railroad Safety Advisory Committee, the Conductor Certification Working Group, to perform the following: railroad safety data bearing on the opportunities to reduce risk associated with the duties performed by freight and passenger conductors, assist the Federal Railroad Administration in developing regulations responsive for the legislative mandate, consider any revisions to the Title 49 Code Federal Regulations Part 240 appropriate to conform upon update certification programs of locomotive engineering conductors. The tasks are also listed requiring specific report what requirements for the training experience are appropriate when the certification of the conductor shall be recognized, to what extent is the extent of the requirements procedures for certification of locomotive engineers provided a module conductor certification, to what extent should unsafe conducting occur when to what extent should unsafe conduct occur while in the locomotive engineering affects certification, such as the status as a conductor as vice versa. Starting with the locomotive engineering certification model, what are the opportunities available for simplifying appeals and discertification decisions for the railroad? The work group was formed for interest organization that the members of the Railroad Safety Advisory Committee, in addition with the Federal Railroad Administration, following the organizational contributed members. The American Association of Railroads includes the BNSF Railway Company, the Canadian National Railway, Canadian Pacific Railway, and the CSX Transportation Incorporated companies, Iowa State Railroad Limited, Kansas City Southern Railway, Northeastern Illinois Regional Commuter Railroad Cooperation, North Southern Folk Company, and the Union Pacific Railroad. The National Railroad Passenger Corporation, Amtrak, the APT, includes the members of the Long Island Railroad, Metro Northern Railroad, Southeastern Pennsylvania Transportation Authority, and Southern California Regional Railroad Authority and Transit Solution Groups. The ASLRRA includes the members of the Anti-Caustic Railway Holdings, Janice William Grome, Omnitrax Incorporated, Rio Grande Pacific Corporation, or the WACO companies include WACOs of the Brotherhood of Locomotive Engineering Trainmen, National Railroad Construction Maintenance Association, including members of the Herzog Transit Services, the NTSB, the TWU, the UTU, the DOT of John A. Volpel National Transportation Service, or the Volp Center, is also contributed with members of the working group. The working group is convened in 6 types of the following dates of location: July 21st to 23rd in 2009 in Washington, D.C., August 25th through 27th in 2009 Overland Park, the Kansas City, September 15th through 17th, 2009 in the Colorado Springs, Colorado, October 20th through 22nd, 2009, Arlington, Virginia, number 1719, 2009, Scottsdale, Arizona, and December 16th through the 18th of 2009 in Washington, D.C. To aid the working group in development of recommendation certification of conductors, the FRA prepared the draft regulatory text for the distributed prior to the July meeting. The draft text closely followed the Title 49 49, Part 240, which governs the qualification and certification of locomotive engineers. During each meeting, work group members make recommendations regarding any changes additional to the drafted text. Following each of the meeting, the Federal Railroad Administration considers the recommendation and revises the draft text accordingly. Minutes of each of the meetings are part of the docket proceedings available for the public inspection. Having worked closely with the Railroad Safety Advisory Committee developing its recommendations, the Federal Railroad Administration believes that the Railroad Safety Advisory Committee effectively addressed the concern with regard to the certification of conductors. The FRA greatly benefited from the opening, informed exchange of information during these meetings. The working group reached consensus on all recommended regulatory provisions on March 18th, 2010, the working group presented a recommendation for the full Railroad Safety Advisory Committee for concurrence. All members of the Railroad Safety Advisory Committee attendance for the March meeting accepted the regulatory recommendations submitted by the working group. Thus, the working group recommendations became the Railroad Safety Advisory Committee recommendation of the FRA. Based on the recommendations of the Railroad Safety Advisory Committee, the FRA published a notice of the proposed rulemaking, NPRM, Federal Register of November 10th, 2010, C75, the FR 69166. In the notice of the proposed rulemaking, the FRA solicited public comment to the proposed rule, notified by the public of its option to request public hearing of the notice of the proposed rulemaking. In addition, the FRA also invited comment on a number of specific issues related to the proposed requirements proposed developing the final rule. In the response for the notice of the proposed rulemaking, the Federal Railroad Administration received written comments by the American Association of Railroads, Amstead Rail, Amtrak's APTA, ASL, RRA, BLET, NYMTA, SEPTA, and the UTU. FRA meet with the working group on the May 12th, 2011 to discuss comments. Minutes of the meeting as part of the docket of the proceedings is available for the public inspection. It is contemplated by the work group task statement the promulgation of the conductor regulation opens consideration conforming the change of the Title 49 CFR Part 240, the qualification and certification of locomotive engineers. Such changes include the amended program submission process, adding the Title 49 Code Regulation 218 Subpart F, violations of revocable offensive handling engineering conductor permit petitions for review for the single FRA board. All FRA intended for the work group to consider changes to Part 240. During this meeting, the work group was unable to undertake the task. Moreover, members of the work group felt that it would be more efficient to discuss changes to Part 240 after the conductor certification regulation is finalized. Therefore, the Federal Railroad Administration expects the working group to continue the meeting after the publication of the rule provided with recommendation for the address and conformity to the change of Part 240. In addition, with the conductor certification work group, interested parties should also be aware of the Railroad Safety Advisory Committee working groups and currently meeting to discuss potential FRA regulations which may impact the conductor certification regulation. The medical standards and safety criteria of the personnel working group, the Railroad Safety Advisory Committee task number 0603, for example, is developing recommendation of potential FRA medical standards regulation. That regulation is promulgated and could supersede some of the medically related requirements of the conductor certification regulation. Further, in training standards plans working in the group, the Railroad Safety Advisory Committee task number 1001 is developing recommendations for the Federal Railroad Administration training regulation. When the Federal Railroad Administration does not accept such as the training regulation superseding the training requirements of the conductor certification regulation, the Federal Railroad Administration does not, at the time, what the final training regulation will provide. Some modifications of the training requirements in this rule may be necessary to conform to the final requirements of the training regulation. Part 4, General Summary of the Comments. As noted by the Federal Railroad Administrative, received written comments to the notice provisions of the rulemaking for various interested parties. Following submission for the comments of the Federal Railroad Administration conveyed that the working group to consider discussing comments. As a result, certain of those comments have been superseded, changed the rule text of the notice of the provisions of the rulemaking to the final rule. They should be necessarily understand and reflect the positions of the commentators with respect to the requirements of the final rule. The FRA is summarizing the comments understood and responding to them, the documents, so that the FRA position are clearly understood. A, the definition, substance, abuse, and Professional, or SAP. The FRA solicited comments on whether the substance abuse professional should owe the duties of both the employee evaluated and the railroad. The FRA noted that the notice provision rulemaking that the duty owed by the substance abuse professionals did not parallel the duty owed by the medical examiner. The Brotherhood of Electric Engineering and Trainmen and the U2U commented that the substance abuse professional owe a duty to both employee and railroad. The definition should be revised accordingly. After reviewing the comments regarding the substance abuse professionals and the comments regarding the drug alcohol rules proposed, the notice provision rulemaking, the FRA finds the definition uses the term SAP, or the notice of provision rulemaking appears to consult with the confusion with the industry may interfere with the DOT's drug and alcohol rules contained in parts 40 of 219. The DOT alcoholic drug rules of the SAP and substance abuse professionals only used when referencing counseling requirements to follow the federal drug and alcohol violation in Part 219 violation. In the notice of provision rulemaking, however, the substance abuse professional is required before the evaluation stemming from the federal violation. Evaluation stemming from the incident did not result in the federal violation, e.g., the motor vehicle alcohol drug incidents identified and pursuant to statute 242-111. More of the definition of substance abuse professionals, the NPR goes beyond the definition in the term of the Part 40, which does not reference the duties of the substance abuse professional. To avoid interfering, establishing definitions contained with the Department of Transportation drug alcohol regulations to avoid confusion in the industry regarding what is required in the federal and non-federal violations. The Federal Railroad Administration is making 3 changes of regulation to propose the National Notice of Provision rulemaking. First, the FRA is deleting the reference to the duty as definition of SAP. Second, the term SAP is part of 242 and will only be used in conjunction with the counseling requirements stemming from the federal violation. For example, a term of the substance abuse professional will be used in part statute 242.11.5F, which discusses the following up of the most often occur within the Part 219 of the violation, but the term will not be used in the statute 242.11.1, which concerns evaluations stemming from the motor vehicle alcohol drug incident. Third, those sections of the part of the 242 will address drug alcohol evaluation requirements not involving with federal violation. The term substance abuse professional will be replaced with the term drug alcohol counselor, DAC squared. As used in final rule, the drug alcohol counselor will be required to meet the exact same qualifications as a substance abuse professional. The Federal Railroad Administration believes that the changes will be avoided interfering parts with 40 and Part 219, which require the same qualification credential requirements for persons evaluating substance abuse disorder proposed in notice provisions rulemaking. Second, the medical examiner, the Brotherhood of Locomotive Engineering and Trainmen, and the U2U commented on prescribed definition of medical examiner should be amended to explicitly state that the medical owner owes the duty to the employer and the railroad. The FRA believes the provision unnecessary given the plain language regulation statement provided by the notice of the rulemaking provisions preamble addressing the issue. The Federal Railroad Administration states that the notice of the provisions of rulemaking 75 FR 69166 and 69170 November 10th, 2010 in the section by section analysis of this rule. Under this rule, the medical examiner owes the duty to be honest and fully informed evaluation condition of the employee. The only difference between the definition of medical examiner in this rule and the definition of Title 49 Code of Regulation Part 240 and the under part of the 240 is the medical examiner owes the duty to the railroad. In the rule, however, the word is to the railroad have been deleted and the change was being made to the address concerning the work group members of the medical examiner should not owe to the just railroad rather than should owe the duty of both railroad and employee evaluated. 3. Job aid. The SCPDA raised concerning the FRA provision proposed the definition of a job aid. According to the SPTA, the job aids provide information guidance on how to perform multitude of tasks. The railroads must have a flexible determining of the scope of their use. The SEPTA asserts that the specific reference to the physical characters and definition of the job aid and unduly prescriptive creates potential misinterpretations, erroneous limitations on such of the tools based on regarding this. The ESPTA expressed concerns that the proposed definition could consider prohibition on railroads for using the job aid for anything of the physical characteristics familiarization. The Federal Railroad Administration believes that the commentary is applying for the term job aid is used in part of the 242 beyond the intended scope. The term only applies to specific information that would provide the specific situations, i.e. information regarding the main track physical characteristics required to provide only in situation of the conductor lack territorial qualification on and other main track physical characteristics, not particularly with the conductor to be assisted by a conductor who meets the territorial qualification requirement. As defined, the term job aid would not prohibit additional information being included in the job aid. Moreover, the use of the term job aid is not intended to prohibit the information of the guidance not covered by the term. The definition, regardless of the information guidance, is called job aid. Because the FRA does not believe the proposed definition could be considered prohibition of the railroad using a job aid for anything other than physical characteristic of familiarization, the Federal Railroad Administration has adopted the proposed definition of this final rule. On the job training, the SEPTA commented on proposed definition of on-the-job training should be replaced with the definition of the term developed by the Railroad Safety Advisory Committee Training Standards and Plans Work Group. At working group meetings, the FRA informed the working group of the conformity requirements developed in the Training Standards Plans Work Group when appropriate. The proper proposed definition of the notice of provision rulemaking made of the definition developed with the Training Standards Plans Work Group, and except the Training Standards definition include on-the-job components of the regulatory task, regulatory text rather than the definitions provided by the notice provision rulemaking. In the final rule, the FRA has adopted the more concise definition on-the-job training developed by the Training Standards of the Plan Working Group and has moved the components to the regulatory text. 5. The conductor of the SEPTA commented on the definition of the conductor should be revised to read: the conductor meets the crew member in charge of the train or the yard crew and is defined as part of the 218 chapter. When the train or the yard crew consists of more than one crew member, the definition of the conductor was subject to the lengthy discussion during a work group meetings. Recommendation work group was adopted by the the notice of the provisional rulemaking. The notice of provisional rulemaking focused on the functions of the person, forms, not on the person, the job title. The SEPTA definitions, however, would diverge significantly from the approach of the notice of the provision rulemaking. For example, the SPTA definition of one person remote, the control operated job would not have conductor, but on the two-person job would. The SEPTA definition would mean that the remote control operator and the one person would not have been engaged in a revocable event for any Title 49 U.S. Code Federal Regulation Part 218 Subpart F violation. The FRA believes that the loophole for the regulation could lead to the less safe work environment of the railroad employees. The definition of conductor is a fundamental element of the conductor certification regulation. The Federal Railroad Administration does not discern any safety-related reason to modify it. Accordingly, the FRA has adopted a definition of proposed provision rulemaking in this final rule. 6. Ineligible and ineligibility. The SEPTA commented on the use of the term ineligible and ineligibility should be limited to the two situations. Initial certification, which individual being considered for certification may not qualify for certification at the time. Recertification, when the individual of a currently certified or due to the recertification but certain circumstances outside the scope of the prohibited conduct would prohibit the recertification of the situation is resolved. And as used by the notice of the provision rulemaking, the terms ineligibility and eligibility are catch all terms that not only encompass the revocation, denial, and certification, including two situations highlighted by the SEPTA, but also cover the other situations. For example, a certified conductor may voluntarily refer to him or herself for the substance abuse counseling treatment under 115D. The conductor refuses to complete the course action recommendation under the provision Title 49 Code Regulation 219-403. Would not be operating the rule procedure of the type of alcoholic drug violation that would require revocation, nor would it constitute a denial of certification in situation. Rather than the conductor would simplify the ineligible until the railroad determined that the person no longer had the substance abuse disorder. The person re-entered the substance abuse program had to be determined under the provision Title 49 U.S. Code Regulations 219-403. The person could safely return to duty under the circumstances. Thus, capture all situation where the conductor may be legally disqualified in the service as conductor. The Federal Railroad Administration believes that it is useful to define in the terms ineligible and ineligibility. The Brotherhood of Locomotive and Engineering Trainmen and the U2U commented that the definition ineligible and ineligibility should be revised. The state of the period of the ineligibility should begin only after the person has been afforded by the applicable due process established either by the statute 242-1009 or 242-115F. Subpart E should end in the conditions contained that therein and are met. The Federal Railroad Administration believes that the Brotherhood of Locomotive Engineering Trainmen proposed that they could adversely impact the railroad safety because of the proposed potential allowed the conductor involved revocable event and to the continuing service of the conductor until the railroad concludes that a hearing and an issued decision. According to the Federal Railroad Administration, declines the implement of the proposal to determine the definition of ineligibility to the proposed notice of provision rulemaking will become adopted in this final rule. Qualified instructor. The SCPTA commented the definition qualified instructor should be replaced with the definition designated instructor. Believed that the Railroad Safety Advisory Committee Training Standards Plans to Work Group and an alternative to the SCPTA commented that the Federal Railroad Administration needs to provide a reference validation of the correlation of the 12 months of experience of the instructional competence, craft qualification, subject matter expertise defined and clarified with the terms of service. Trained services limited to certified conductors, whether the term includes engineers, brakemen, assistant conductors. Definition of designated instructor developed by the Railroad Safety Advisory Committee Training Standards and Plans Working Group refers to as a person designated in such an employer training organization, learning institute with demonstrated pursuant to the training program submitted with the employer training organization or learning institution and adequate knowledge of the subject matter under the instruction with the applicable necessary experience of the effectively provided with the formal training. Although the final rule generally conforms to the provision of the terms developed in the train standards of the plans working group, the Federal Railroad Administration believes it appropriate to go beyond the requirements with respect to the definition of a qualified instructor. The definition of qualified instructor in the notice provision rulemaking and designated instructor developed in the training standards and plans work group are similar to one of the two exceptions. Unlike designated instructor, a definition of qualified instructor requires the instructor to certify the conductor. In the case of the railroad designated employee representation, to designate the railroad concurrence with designated employee representative to have minimum of 12 months servicing work as a training service employee. As stated by the national rule, the notice of provision of rulemaking, additional requirements would include here to the address concerned with the work group members of the employees through the representative should have input the selection instructors but might be viewed and experience the person with less than 12 months of service working trained service employees. The Federal Railroad Administration believes the requirements will contribute to better training and thus safer the workforce. According to the FRA, declines to modify the definition of qualified instructor to define the designated instructor that is developed by the Railroad Safety Advisory Committee Training Standards Planning Work Group. The SCPTA comments demonstrates the need to clarify the meaning of the term trained service employee. The purpose of the definition of qualified instructor in this final rule, the Federal Railroad Administration added the terms of the trained service employee to include those persons with the traditional being known as the certified engineers, conductors, brakemen, yard helpers, or yardmen. The minimum 12 months servicing working as a trained service employee may be able any time during this person's career. B, the waivers. The Federal Railroad Administration solicited comments whether the Statute 242-9 of the National Notice of the Provision rulemaking dealing with waivers should be removed unnecessary to lighten of the fact that the Title 49 Code Federalization Part 211 addresses the waiver process with all three common enters on the section. The SPTA, AAR, and the BLET-U2U agree that the waiver process will be covered in Part 211 of the American Association of Railroads and the SPTA indicated the different elimination of the statute 242-9. However, the U2U and the Brotherhood of Locomotive Engineering Trainmen suggested that it may be helpful to lay out lay people who not be aware of the contents of Title 49 CFR Part of 211. To retain the reference of waiver of the process of 242.9, the FRA agrees that the statute 242.9 may be helpful to some people, therefore retain the section of final rule. C. Certification programs. The FRA solicited the comments of whether the amount of time proposed of the implementing conductor certification based on the data provided is approved. The FRA does not receive any written comments of the issue, but did receive the feedback during the May 12, 2011 work group meeting regardless of the extension of the effective date of the rule. However, the FRA believes that this proposed approach is responsible thus the time periods proposed in the notice provision rulemaking will be adopted in this final rule. D. The schedule of the implementation. The AAR seeks to confirmation with that any employee can be designated as a conductor under the grandfather provisions through January 1st, 2012. An employee designated the conductor under the grandfather provision can serve as the conductor in July until June 1st, 2015 without being tested, evaluated pursuant to Subpart B. Issued certificate pursuant to Section 242.207. The AAR summary is designated provision of 242.105 is not entirely accurate with respect to the time period designated conductor. Only the person authorized by the railroad to perform the duties of conductor between the January 1st, 2012 and January 1st, 2012 clear Class 1, Class 2 railroads, and January 1st, 2012 to October 1st, 2012 the Class 3 railroads will be designated as a conductor with respect to the time period designated. The conductor may serve as without being tested, evaluated as a person designated with the conductor pursuant to the statute 242.105 may not serve as a conductor after June 1st, 2015 as Class 1, Class 2 railroad, or October 1st, 2015 Class 3 railroads without being tested, evaluated pursuant to Subpart B. However, March 1st, 2012, each railroad must issue a certificate complies with the statute 242.207 to each of the person that designates more of the subject provision 242.105C133. Railroad must evaluate designated conductors under Subpart B from before 36 months. Designated period has been expired. Railroads should not only note that they must not test, evaluate designated conductor candidate under Subpart B of this rule. Revoke the conductor certification, including designated conductor certificate, until they have certificate program approved by the Federal Railroad Administration pursuant to 242.103. E. The prior safety conduct of the motor vehicle operator. The SEPT commented an additional language should be added to the regulation that specifies the delay of the receipt of the required driving record to be due to acts and omissions of the driver license agency. If the 60-day extension is limited to those in the case where the delays are beyond the control of the individual. According to the SEPTA, absences of such language could force the railroads to impose more or serve in time restriction of the driving record and information requirements, effectively penalizing the majority of the employees for the sake of the few who attempt to beat the system. Remaining the safety of critical environmental will be affected with the active substance abuse disorder. The FRA acknowledges the SPTA concerns. The FRA has not seen evidence of submission of incorrect, misleading information. Driver license agency and common problem. If the FRA finds such evidence, the FRA will consider amended to Part 242 to address the issue. The interested parties should know that any of the person knowingly and willfully falsely as a record report and required part of the 242 may subject to the criminal penalties of the Brotherhood of Locomotive Engineering Trainmen and the UTU commented on the that they accept the application of proposed 111, which addressed the petition to the waiver motor vehicle check requirements of the Railroad Safety Board with required notarized declaration, affidavit, some other form of the sworn statement. The number of the 242.111 incident has occurred with the proceeding of 36-month conditional precedent, the granting of the waiver petition based on the explanation of the Brotherhood of Locomotive Engineering Trainmen and the UTU suggested that the requirement could be written discrete into the rule through relieving the Railroad Safety Board on the burden of having to handle these matters. The FRA declines on the adopted suggestion. The FRA cannot speak to what the Railroad Safety Board may require with respect to the waiver of certain requirements of Statute 242.111. Moreover, than beyond the rules of making the remove the railroad right the petition Railroad Safety Board for the waiver of the FRA regulation requirements. The AAR commented on paragraph 05 should be added to 242.111. That would be permit the railroads to offer the assistance of the licensed counselor, social worker, and psychologist will experts in assessment of the people with the substance abuse disorder as an alternative to the substance abuse professional. According to the AAR, the employee could use the substance abuse professional if the employee desired, but the railroad would be able to offer the employee a choice. Pursuant to the Section 242 of 111, the notice of provision railroad employees will be evaluated substance abuse disorder by the person, the drug alcohol counselor, who meets the credential qualification requirements of the state of substance abuse professional with the most stringent credential knowledge requirements of the EAP counselor currently used in Part 240. The type of the person proposed in the AR-FRA believes that requiring more stringent credential knowledge requirements will improve the employee confidence in the evaluation process. Moreover, the AAR approves that can openly open up possibly harassment, intimidation employee who does not choose to be evaluated by stringent credential knowledge requirements of than a substance abuse professional. According to the FRA, declines to adopt the paragraph proposed by the AAR. The AR commented that it appears that the FRA intends the DOT requirements for the direct observation urine collection to apply the following tests required in the result of the motor vehicle alcohol drug violation. The AR would agree to the position suggesting the FRA should make clear that both regulations in Part 240, where the follow-up of the testing is required by the federal rules, all federal testing requirements include the direct observation to apply. If it is not the FRA's intention for DOT requirements for the direct observation of urine collection applied to the following tests required as a result of the motor vehicle alcohol drug violations. A motor vehicle alcohol drug incident requires the following up of the test is not a federal Part of 219 violation. As such incidents do not meet the criteria justifying direct observation provided by the Title 49 Code Federal Regulation 40.67. Interested parties should note that, however, the direct observation of urine collection for the following up the test may be recommended to the drug alcohol counselor as necessary. F. Substance abuse. The Brotherhood of Locomotive Engineering and Trainmen and the UTU commented on the guidance provided by the Notice of Provision rulemaking concerning circumstances which may indicate the need for a substance abuse professional evaluation, i.e. declining for the job to perform and extreme mood swings or irregularity. Attendance should be removed from the preamble. The Brotherhood of Locomotive Engineering Trainmen and the UTU asserts the circumstances identified with the ambiguous subject concepts which could be exploited by the railroads. The FRA acknowledges that there could be legitimate reason why someone might exhibit some or all a condition identifying the preamble of the Notice of Provision rulemaking. However, these conditions extend for the not immediately expectable must indicate the need for evaluation. The purpose preamble of the language does not require the railroads to order an evaluation of any time listed condition exhibited. Rather than the FRA is simply providing guidance for the condition that they may, or given the context, call for the evaluation under an internal railroad policy. Moreover, the FRA remains vigilant of harassment and intimidation, will take appropriate action where such conduct is discovered, and accordingly the guidance and notice provision rulemaking has been covered or carried over the final rule. Brotherhood of Locomotive Engineering Trainmen and the UTU commented on 242.115 of the Notice of Provision rulemaking contains several references to certification consequences for employees who refuse or fails to provide breath or body fluid samples. The Brotherhood of Locomotive Engineering Trainmen and the UTU disagrees with the failure to provide breath or body fluid samples should trigger the revocation of consequences. According to the Brotherhood of Locomotive Engineering Trainmen and the UTU, there are legitimate medical reasons why a person may be unable to provide a breath or body fluid sample, citing the Title 49 Code Federal Regulation Part 40, Subpart I, which provides a medical condition under an individual's failure to provide a sufficient sample is not to be deemed refusable. In addition, the Brotherhood of Locomotive Engineering Trainmen and the UTU notes that Subpart G of the Part 219 excuses covered an employee for the compliance with the requirement participation in random drug alcohol testing. In the case of the documented medical and family emergency, see 49 CFR 219.603 and 219.609. Brotherhood of Locomotive Engineering Trainmen and the UTU understands the reference to Part 219 proposed in Section 242.115E. 2. As incorporating exceptions set forth by Subpart G, requesting subsection analysis final rule clarifying that their understanding of this is correct. The FRA confirms the exception in Part 40, Subpart I, the Part 219, Subpart G are included in the final rule for the use of the words refuse. In other words, there is no refusal for the failure to provide the sufficient samples as a result of legitimate medical examination explanation under Part 40 if it was random tested and the employee had a documented medical or family emergency under Part 219. Further, to clarify the issue, the FRA has removed or fails the final rule and for the use of word refuses rather than the phrase refuses or fails must accurately tracks the provision in Part 40 in 219. G. Visual and hearing acuity. The Brotherhood of Locomotive Engineering Training in the U2 commented on proposed 242-117K should be amended to address concern discovered after the incident. The conductor's vision, hearing, and activity deteriorated below the set forth by the National the Notice of Provisional Rulemaking with the conductor, even though he or she may not have been aware of the deterioration, must be subject to penalties, enforcement actions, but for the failing notified the railroad deterioration prior to the incident. The FRA understands the the Brotherhood of Locomotive Engineering Training in the UTU concerns believes and obvious that the conductor could not have enforcement action taken against the failing of notifying railroad condition he or she was not existed. This is why the preamble discussing the section National Notice of the Provision Rulemaking noted in the paragraph as word is if the issue would address the issue how soon after learning the deterioration the conductor would have to be notified the railroad of the deterioration. The 75 FRA 69166 and 69176 notice number November 10th 2010 emphasizes added because of the proposed regulation would not permit the enforcement action against the conductor for the failing of notifying the railroad when they are not aware of their vision or hearing acuity and have been determined below the standard of the regulation. For the FRA declines to adopt the BLE, the Brotherhood of Locomotive Engineering Trainmen, and the UTU's proposed amendment. H. Training.